Okay. Good afternoon, ladies and gentlemen. Today, we will deal with a proof of negligence, the basics of product liability, and other sectors of gray area of tort laws, now evolving to respond to the industrial transformation or scientific reorientation of the prevailing social perception. Beforehand, I'd like to get you on the images of cigarette packet and some of others. Do you smoke? Of course, college students are considered normally an adult to be eligible to vote and thus open-minded with the smokers. Are you? Given that a portion of students are veteran or aged ones, I also guess fairly number of students now smoke or experience smoking who may quit for various reasons. But have you noted the recent stricture about the smokers? And also, are you one of them to segregate the smokers in the society? Personally, I have long been a heavy smoker and now also consumes virtually one packet of cigarette per day. Actually, I enjoy it, but I suffer from antagonists who detest it. Of course, the principal actor to suppress my smoking is my wife. Whenever I smoke, she expressed her fear from its ill effect on human health and turned to be a phobia to implore its critical consequences. I normally have no mind about it, and I locate a hideout for undisclosed smoking. Cigars and smoking, I personally think, have history on trend over the centuries. The human perception have changed. Originally, the product was considered to be a precious thing for noble class, and one of the popular objects that the Western empires exploited the colonial states. For the feudal Koreans, the cigarette was first landed on this peninsula around 13th century and was consumed for limited class of social prestige at that time. The cigars at its inception was believed to expel some of illness and was viewed in some context to be effectively used to assuage the pain of persons. It represented a social prestige at that time, and thanks to mass production of it at the modern era, it turned to be highly commercialized for the poor classes to taste it. Over time afterwards, it is now normally perceived as a cheap time killer for lay persons and social laborers that have a high potential to affect the neighbors. For the second perception, as you know, was generated due to many of scientific efforts for more quality livings. Do you agree? Nobody expects the current en vogue to argue the harm of cigarettes in the courtroom across the country if he or she is a person of the 13th century. That art would also continue through the first half of the 20th century, although the product, what I call cigarette, is consumed by a vast majority of common people. Due to the names who long struggled with the tort damages that was alleged to be caused from the consumption of cigarettes, the tort actions on cigarette issue are normally raised in the form of class action and also entails heavy implications as one of public issues involving many interested parties. The litigation was framed as one of negligence tort, now that the proximate cause or other duty of care concept would be critically weighed in to resolve the case. The area of concern may also be related with the proof of negligence. How do you suppose if a kind of a shifted burden of proof were to be set forth to deal with the question? A strict liability or a kind of product liability may qualify to be applied. The point of consideration would be viewed through the class. Let us get back to the picture shown in the projection. The name of cigarette is raison, that I suppose was to be created by Korean form, which means reason in French word. When you say raison d'etat, it means a reason of state or nation. The German teacher has conceptualized in his philosophical discourse. Do you see any paradox that the kind of dangerous product is titled raison? Or can you second guess if the smoking can allow us to restore to our reason from the time of unsought automatism and days of circular schedule? As you have learned in the last class, the reasonable prudent person standard is required to be applied to find in negligence, which is mostly panacea to find a fault, and finally tort liability. If you are draft of tort law, do you still endorse its prevailing status to represent the era of enlightenment, industrialization, mass production, and mass consumption era? Once again, the ultimate goal of tort liability lies in the better allocation of resources. On this stream, the policy team of Korean presidential candidates recently expressed its favor to impose punitive damages against some of culpable acts of chaebol. In some context of postmodern period, the modern prevalence of reason may vitiate our sense of justice, in the least surrounding the civil context. The Hegelian concept of reason, of course largely crafted on the basis of West, brought the consequence of modern civilization. The latter take in my submission the threshold of evolution to lead to the fascism, Marxian materialism and internationalism, and Bertrand Russell's analytical reasoning of philosophy. Do you agree if the fascist can easily be bred upon the realistic mind of the might of political power? Given the developing or solitude status of the United States at that time, Hitler may convince himself as a mighty political power. Then, did we correctly call Du Han-jun a fascist during the time of 1980s in Korea? Why did Bertrand Russell urge on the clarity of continental philosophers after experiencing the catastrophic World War, who is considered to lay a foundation of Anglo-Saxonian school of modern philosophy? Who is Bertrand Russell? Russell, at the time, led the British revolt against idealism in the early 20th century. He is considered one of the founders of analytic philosophy, along with his predecessor Gottlob Frege and his protege Ludwig Wittgenstein. He is widely held to be one of the 20th century's premier logicians. He calls with A.N. Whitehead, Principia Mathematica, an attempt to ground mathematics on logic. His philosophical essay on denoting has been considered a paradigm of philosophy. His work has had considerable influence on logic, mathematics, set theory, linguistics, computer science, and philosophy, especially philosophy of language, epistemology, and metaphysics. The word reason, or largely Western reason, posited a fairly grand scale of consideration when you think about the political or public issues. What is the reason of state as espoused by Hegel? I'd like to show the last picture about some book. It may, in some cases, come forward with the word reason or largely Western reason, posit a fairly grand scale of consideration. What is the reason of state or nation as is posed by Hazel? It may, in some cases, come forward with the Super 301 from the recent trade issues, the largest slant on the unilateral justice of the United States, which is criticized heavily by international circle of trade lawyers, but have a solid ground from the logic of domestic legalists. In other cases, the reason may be related with the realist concept of international politics, to forge the values of the state. Do you see correctly attributed that the apartheid of South Africa has to be sanctioned because of any kind of unreasonable practice? Can it be proper to call the state a rogue state rather than the state of reason? How do you see such long negotiation between the United States and North Korea to settle the nuclear issues? Do you prefer the word American justice rather than American reason? How do you connote those words in a nuance? If action or real power can be asserted, do you agree that the reason converts into justice? Do you personally prefer that the justice is better to rest within the national context, like the Supreme Court justice or others? In this context, I like to suggest one reading titled Policing the American Empire. And the picture shows the sample books I've retrieved from the site of Amazon. The book title is Policing American Empire in the United States, the Philippines, and the Rise of Surveillance State, authored by Alfred A. McCoy. Alfred McCoy is J.R.W. Smiley Professor of History at the University of Wisconsin-Madison, and his book includes the politics of heroin and a question of torture. In this book, the author argued as follows. Security techniques bred in the tropical hothouse of colonial rule were not contained. The author shows at this remote periphery of American power, migrating homewards through both personnel and policies, these innovations helped shape a new federal security apparatus during World War I. Once established under the pressures of wartime mobilization, this distinctively American system of public-private surveillance persists in various forms for the next 50 years as an omnipresent sub-rosal matrix that honeycombed U.S. society with active informers, secretive civilian organizations, and government counterintelligence agencies. In each succeeding global crisis, this covert nexus expanded its domestic operations, producing new contraventions of civil liberties, from the harassment of labor activities and ethnic communities during World War I, to the mass incarceration of Japanese Americans during World War II, all the way to the secret blacklisting of suspected communities during the Cold War. So there are some distinct elements that the United States have practiced this scheme of empire, and do we have to police it? For this book, there are several comments from a very familiar scholars of influence. For example, Noam Chomsky. Have you come across the name of this scholar? He's a professor of Massachusetts Institute of Technology. And also one comment came from a Bruce Cummings, who served the University of Chicago, and is considered a very influential scholar to research very powerfully about also about South Korea. He several times visited South Korea. It may seem to be a jungle for the foreign policy makers and diplomats, although we have a kind of institutional arrangement, such as UN Security Council. South Korea recently re-entered one of council members, and it symbolized the pacifist framework, as like the recent announcement from new Chinese leader Xi Jinping. It is also interesting to see that one U.S. diplomat sought to obtain some kind of clarification about Xi Jinping's message, coexistence in peace. That is perhaps likened to be a Bertrand Russell suspect or suspect of analytical nature. But do you agree about the geopolitical restructuring recently charted in this area of East Asia? Let us return to some kind of U.S. trade laws. The statutory provision used the word unreasonable or unjustified. You can find that was in a Super 301 to decide the states practicing unfair trade against the United States trade interests. Can you distinguish both words, or how do you perceive the extraterritorial application of national laws? How can you make your point to propose this legitimacy? And this point of consideration, we need to understand the Westphalia Treaty in 1678 that is considered to give the birth of modern form of state. That is why the treaty, what we call a Peace of Westphalia, is in the embarking instant to found the modern framework of international law, legalizing the concept of a state sovereignty. From this time on, the state is considered an independent entity, like emancipated slave, to free contract to make a treaty and treat it as equal among each other in legal terms. And that actually coincides with the demise of absolute dominance of Roman Catholic and rise of a Protestantic Christianity. What is a Peace of Westphalia? It was a series of peace treaties signed between May and October 1648 in Osnabrück and Münster. These treaties ended the 30 Years' War in the Holy Roman Empire and the 80 Years' War between Spain and the Dutch Republic, with Spain formally recognizing the independence of Dutch Republic. The Peace of Westphalia treaties involved the Holy Roman Emperor, Ferdinand III of the House of Habsburg, the Kingdom of Spain, the Kingdom of France, and the Swedish Empire, a Dutch Republic, the princes of the Holy Roman Empire, and sovereigns of the free imperial cities, and can be denoted by two major events. And Baba. The regional justice is operating in a kind of limited context in political and public sectors because the realist influence is very dominant actually at the global context. As you see, most close to this debate are probably NGOs. You know, NGOs, non-governmental organizations, which are now interacting as one of bulwark to monitor the operation of global reason. NGOs, however, are just one of interested group that lack any power to enforce its policy. And it is also subject to division in some kind of global issues. While the North and South hemisphere have different minds or way of approach against the issues presented. The developmentalists may do not agree on the radical reforms about the action to preserve the environment. But do you agree it to be acceptable that we turn to be gloomy at our bed to see the morning sky in red color? If we are just salary work in a small business firm, who benefit to sacrifice us? Do you see it a kind of injustice? Then any damages can be claimed as a matter of tort law. While there are chances to see more justice in the area of private laws, that is also not a case when it takes time to consider. One of shocking incidents is the Beaufort case. Which killed thousands of people of India in 1970s. The case arose from the leakage of fatally intoxicating materials and killed a surprising number of victims. You may experience a similar pollutive happening in Chilgok, South Korea recently. The kind of industrial disaster is devastating in there to cost many victims and financial losses. You may also be familiar with the scene of oil spillage as occasionally spotted across the globe, which one time occurred in Taean, South Korea. The action was filed to seek damages in Beaufort case. How do you frame the cause of action? And if you approach in total negligence, is it fair to address the situation? How do you collect your evidence of fairly confidential and highly technological nature? Can you see it easy to establish a prima facie case, or do you find it more plausible to reach a settlement? How do you respond to potentially different dealings of Indian tort laws? Is a reasonable stand-up person the same to the United States, that of the United States or other civilized countries? Then you may turn to be a strategist to efficiently address the interests of a client. That is not just hypothetical, but actually occurred in the Beaufort instance. The case was tried in dual forum. One is within a jurisdiction of New York State in the United States, and others in the Indian court. There is one of representative case about the theory of forum nonconvenience. The New York court did not exercise its jurisdiction on the basis of that theory, because most of pertinent evidence are actually present in India. I will remark on the importance of science that can possibly change the landscape of our perception and adherence on the reason. Although not a case of tort laws, some updated example can be found in Samsung's patent dispute with Apple. It is a multinational enterprise that has many overseas branches. That is the factor that internationally multi-suits were filed to claim the cause of action against Apple. The outcome of litigation actually differs, as you know. How do you perceive it? Do you just suppose it is kind of a homo trend of a forum jurisdiction? Or do you see any difference in terms of reason or scientific standard? The issue is not so simple that may involve a difficult province of patent laws and others. But the example can be kind of potential conflict when we expand our eyesight on the practice of international private law. Now we return to the original scene about the cigarette packet. How do you think about the odds of success if the class action were tried in some of other African states rather than Korea? Do you have same standard of care? Any nexus can be established to claim the jurisdiction of other states? Do you think it is proper to force non-smoking plan even on the public street like Gangnam, Seoul, or New York? Now I'd like to show you a famous entertainer in South Korea. His name is Hung-Guk Kim. His surname is Kim, which is the most popular one in South Korea. And a Chinese name indicates with the first character an excitement or exciting, and second one denotes a nation. Are you exciting with a South Korea? How do you enjoy the recent presidential race in South Korea? He was once been aggrieved about his disengagement and had his hair cut to protest against, but he returned to hold a talk show. But you may see him in a local cave TV. This body. After dancing and singing to fan the Gangnam style of Psy, do you like to feel desolate without one smoke of a cigarette? How about the second picture of Hung-Guk Kim? Can you imagine if any successful nationalists are pumping on the way in a delight and amusement? Are we afraid if we may fall into pitfall to become a fascist? How can you agree on the possibility of American fascism that can in some aspect be seen as more adaptive to this intensified technological internet era? Do you agree that some of destination, after sharing a common knowledge and intelligence with the help of internet, would be a nationalist or fascist rather than internationalist? Just a rough stage of globalization, are we reserved for more concrete power or realistic minds as the version of political power? Do you know Professor Fukuyama, who is very asserting about the true nature of political power? If you are a citizen, how do you distinguish the role of international police power and fascism? Are you actually interested and exalted to see the current presidential election of Korea, as the name of Hung-Guk Kim implies? Or do you find the current election disappointing? If you are a national lawyer, you would experience many of international issues when you are actually engaged in the law firm or work as jurists in other contexts. Given many of us in your future, we now turn to see the basics of tort law in the common law context. We have talked about briefly that of the difficult thing, our reason. Let's get back to some more music titled Naturally, Alone Again Naturally.
Wait a little while from now, not feeling any less sound, I promised myself to treat myself and visit a nearby town. And climbing to the top, throw myself up in an effort to make clear to whoever what it's like when you're shattered, left standing in the lurch at a church where people were saying, my God, that's tough, she stood him up. No point in us remaining, we may as well go home, 'cause I did on my own, alone again, naturally. To think that only yesterday cheerful, bright and gay, looking forward to what wouldn't do the role I was about to play. But as if to knock me down, reality came around, and without so much as a mere touch, cut me into little pieces, leaving me to doubt. Talk about God in His mercy, if He really does exist, why did He desert in my hour of need? I truly am indeed alone again, naturally. It seems to me that there are more hearts broken in the world that can't be mended, left unattended. What do we do? What do we do? Whatever else that appears, I remember I cried when my father died, never wishing to hide the tears. And at 65 years old, my mother, God rest her soul, couldn't understand why the only man she had ever loved had been taken, leaving her to start with a heart so badly broken. Despite encouragement from me, no words were ever spoken. When she passed away, I cried and cried all day, alone again, naturally. Alone again, naturally.
How have you enjoyed the music? Turned to be good to audit the class? Okay. Now, we briefly investigate the issue of a proof of negligence. You may refer to the summary displayed in the projection. People of reasonable intelligence may differ as to the conclusion to be drawn. The issue must be left to the jury. If not, the court will decide. Generally, the burden of proof to say the risk of non-persuasion is on the plaintiff. And if the evidence she introduces is not greater or more persuasive than that of her adversary, she must lose. The burden of going forward with presenting proof, on the other hand, is established by presumptions. And the failure to rebut a presumption may result in a directed verdict. Circumstantial evidence is the proof of one fact or a group of facts that gives rise to an inference by reasoning that another factor must be true. You need to know a res ipsa loquitur, which is the basic, a starting point about a proof of negligence issue. We brief it as RIL. Directly translated means the thing speaks for itself. In situations where it is highly probable that the injury would not have occurred in the absence of someone's negligence. Second, the indicated source of the negligence is within the scope of duty owed by the defendant to the plaintiff. And third, neither the plaintiff nor any third party appears to have contributed to plaintiff's injuries. An inference is permitted that the defendant was negligent without any direct proof, and the defendant then has the burden of going forward and introducing evidence to overthrow the inference. The courts recognize RIL because of the existence of a necessitous plaintiff and the defendant's better access to the evidence concerning the cause of the injury. Res ipsa loquitur doctrine is applicable if, first, the accident is kind that will not normally occur without a someone's negligence. The cause of the harm was in the complete control of the defendant, and the plaintiff did not in any way voluntarily bring about the harm. If these three elements are proven, plaintiff need to prove nothing else to establish liability. Res ipsa loquitur puts the burden on defendant to explain away the negligence. However, the doctrine does not apply if negligence of defendant is no more likely than another explanation. In other words, when an order inexplicably runs off the road, but is subsequently found to have a flat tire, one of a typical example. There must be some evidence of negligence. If control of the instrumentality by defendant gives rise to an inference that it happened from lack of care, if it would not ordinarily happen without a lack of care. The doctrine does not apply unless reasonable persons could not disagree that 51% of the probabilities point to defendant's liability. A plaintiff did not explain away all possibilities as long as she shows that such an accident ordinarily does not occur without negligence. You can see in the next box describing the summary of a defenses based on a plaintiff's conduct. You need to focus on 4 types of defenses, including a contributory negligence, and last clear chance rule, and assumption of risk issue, and also need to know a comparative negligence, which is similar to the prescription of Korean Civil Code. Contributory negligence is conduct on the part of the plaintiff that contributes as a legal cause to the harm he has suffered, where the conduct falls below the standard to which he must conform. Contributory negligence is much like negligence itself. The criteria are the same, but it involves a person's duty to exercise a reasonable care for his own safety rather than the safety of others. While the formula for determining negligence and contributory negligence is the same, the results are not necessarily the same. The same act may be negligent when done by the defendant, yet not so when done by the plaintiff. The standard of care, as in negligence, is determined by what the reasonable person would have done under the same or similar circumstances. For those states still retaining contributory negligence, the prevailing rule is that plaintiff's action for negligence is barred by his own negligent conduct, if such conduct is a substantial factor in bringing about his injury. Thus, its effect to give defendant a complete defense, no liability to defendant. The burden of pleading and proving contributor negligence is on defendant. Contributor negligence should be distinguished from avoidable consequences if plaintiff fails to act as a reasonable person in order to mitigate his damages. He will be barred from recovering for the damages that could have been avoided. Note that this doctrine is a rule as to damages and not as to liability. Although contributor negligence will normally act as a complete defense, there are several circumstances or situations in which the defendant will not be allowed to use it. We now a brief on a last clear chance rule. This doctrine was promulgated to ameliorate the harsh effects of contributor negligence as complete defense. It applies where the defendant was negligent and the plaintiff, though his contributor negligence placed himself in a position of either helpless or inattentive peril. If the defendant had the last clear chance to avoid the accident, plaintiff can recover despite its contributor negligence. Less clear chance situations may be classified into 4 categories, in each of which both plaintiff and defendants are negligent. In the case where plaintiff is helpless, then what sequence has been brought? If defendant discovers plaintiff and his peril and fails to use reasonable care to avoid injuring plaintiff, defendant is liable to plaintiff. If defendant fails to discover plaintiff or his peril and is negligent in not doing so, defendant is liable to plaintiff. There is some case where plaintiff is inattentive, then what consequence the law brings about? In attentive peril cases, plaintiff could have recognized the peril if he had been looking and could have protected himself. If defendant discovers plaintiff and his peril and plaintiff's inattentiveness, yet fails to exercise reasonable care, defendant is liable to plaintiff. If defendant does not discover plaintiff or his peril or his inattentiveness, defendant will not be liable on the prevailing view, even if he could have discovered the situation by conducting himself as a reasonable person under the circumstances. When it's considered a defense arising from assumption of risk, when a person assumes the risk in the course of action or his their livings, then they have to protect against the harm he incurred on the theory of negligence. Let's see. The defense of assumption of risk arises when the plaintiff voluntarily encounters a known danger and by his conduct expressly or implied consents to take the risk of danger. In such case, the defendant will be relieved of responsibility for his negligence. Plaintiff's voluntary assumption of risk need not be a negligent act on his part. A spectator at a baseball game may be held to assume the risk of flying balls, but there is no negligence in going to a baseball game. On the other hand, plaintiff's action may constitute contributory negligence, where plaintiff is unreasonable in assuming the risks of defendant's conduct. In order to find a defense varied, the knowledge element has to be present. The knowledge is required to find an assumption of risk defense effective. Plaintiff may be contributory negligent for failing to discover danger that a reasonable person should be aware. However, there can be no assumption of risk where plaintiff had no knowledge or awareness of the particular danger involved. And it must be voluntary. plaintiff's assumption of risk must be voluntary, and if defendant's acts leave plaintiff with no reasonable alternative to encountering the danger, then there is no assumption of risk. Writers have consistently attacked the assumption of risk. Some courts have come out rejecting assumption of risk completely by stating the one must either find contributor negligence or plaintiff's consent to negligence, which simply means the defendant owed him no duty. That is the approach that most courts adopting comparative negligence have followed. Lastly, we need to look into the comparative negligence, which is brief. A comparative negligence is a civil law doctrine. In admiralty law, it is followed in all countries adopting the 1909 Brussels Agreement, but the United States admiralty law did not adopt it until 1975. In the United States, comparative negligence is generally a creature of statute. Such statutes provide for apportionment of damages between negligent parties who injure one another in proportion to their fault. Some form of comparative negligence has been adopted in over 40 jurisdictions. Such legislation is an attempt to provide a system where an act of contributory negligence would not be a bar to recovery. Courts are very reluctant to apportion damages between a negligent plaintiff and a negligent defendant in the absence of such a statute. Now we see some of the introductory part of a product liability. At early English common law, liability for defective products was grounded in either contract or tort. Originally, the action in tort was in the nature of deceit, an action on the case by the purchaser for breach of an assumed duty. By the beginning of the 19th century, the plaintiff action gained substantial recognition in contract, but only those injured a plaintiff's improbity of contract with the manufacturer or supplier of the defective product were permitted a cause of action against them. This cause of action, sounding in contract, was in assumption, either expressed, implied in fact, or implied in law, and the recoverable damages were determined by application of the Hadley versus Vaccine laws. In 1842, Lord Ebinger in Winterbottom versus Wright rejected the claim against the coach of a repairman by a passenger injured when the coach collapsed, stating that the most absurd and outrageous consequences would result if those not in a probity of contract were allowed to sue in contract. Thus, early cases sounding contract developed the probity of contract theory as a shield to the manufacturer and the supplier of a defective product, not in probity with the injured plaintiff. In the past, courts required probity of contract between the plaintiff and the defendant as a precondition to finding of liability. Unless the injured plaintiff was the buyer, no recovery could be had, either in tort or in contract, no matter how negligent the seller's conduct. However, this notion and the concept of probity have been stretched by the courts and in some instances entirely discarded or modified by statute. About the private requirement, we need to note its nature, including the old rule, and this rule was developed in new rule, and the core rule in Macpherson case we shaped a basic elements about a non-private law. So let's see. In the case Winterman versus Wright, the court held a contracting party who has not undertaken a public duty is not liable to serve persons for injuries that result from his negligent performance of the contract. But this traditional law would change it. In a Mexican case, let's see, the court held a privity between the manufacturer and plaintiff is necessary. It is not necessary for plaintiff to be allowed to recover against defendant. The rule as originally propounded by the court in Macpherson was as follows. If a reasonable person would have foreseen that the product would create a risk of harm to human life or limb if not carefully made or supplied, then the manufacturer and supplier are under duty to all foreseeable users to exercise reasonable care in the manufacture and supply of the product. This Macpherson rule was later extended to cover various elements for damage to product sold resulting from its own defects, damage to a reasonably foreseeable non-users in the vicinity of the expected use of product, damage caused by defects in design as opposed to defects in manufacture. The rule also was extended to case the damage to property in the vicinity of expected use where the product itself is dangerous to life and limb because it is negligently made. And liability for products negligently manufactured but posing a foreseeable risk to property only. Liability of a processor of a product at an intermediate stage. And liability of one who sells another product at his own, including dealers, distributors, and any other party in the claim of a sale. So the Macpherson rule gave a foundational framework to cover various cases that we practically included. What is about causation? We need to think about in some kind of a intermediary's negligence. A restatement second of tort section 410 placed a duty on dealers and distributors to make a reasonable inspection of their products that are inherently dangerous in normal use and to remedy or warn buyers against such defects or dangers. The failure of the dealer to inspect, however, does not relieve the manufacturer of his obligations, since the dealer's omissions are considered foreseeable. However, Section 402 of the restatement does not place such a duty on the dealer, where the products are manufactured by others and are not inherently dangerous in normal use. In such cases, the manufacturer is still liable under the Macpherson law, and the dealer may be liable under the theory of warranty or the theory of a strict liability. But if the dealer discovers the defect, the common law rule will make him liable to any injured plaintiff who was not warned of the defect prior to the sale. This failure to warn of known defects also will operate as an unforeseeable intervening force with respect to the manufacturer's negligence and will relieve him of liability under negligence theory. So now, time is up, so we call the class ended. And in next class, we'll Okay, more review about the rest of my product liability and return to the quotation issue briefly. Okay, see you in the next